5 seconds to go. Start. In respect of the possessory claim of the Hindus to the composite whole of the disputed property stands on a better footing than the evidence adduced by the Muslims. The Muslims were dispossessed upon the desecration of the mosque on 22nd and 23rd December 1949, which was ultimately destroyed on 6 December 1992. There was no abandonment of the mosque by the Muslims. This court, in the exercise of its powers under Article 142 of the Constitution, must ensure that a wrong committed must be remedied. Justice would not prevail if the court were to overlook the entitlement of the Muslims who have been deprived of the structure of the mosque through means which should not have been employed in a secular nation committed to the rule of law. The Constitution postulates the equality of all faiths. Tolerance and mutual coexistence nourish the secular commitment of our nation and its people. The area of the composite site measures about 1500 square yards. While determining the area of land to be allotted, it is necessary to provide restitution to the Muslim community for the unlawful destruction of their place of worship. Having weighed the nature of the relief which should be granted to the Muslims, we direct that land measuring 5 acres be allotted to the Sunni Central Waqf Board either by the central government out of the acquired land or by the government of Uttar Pradesh within the city of Ayodhya. This exercise and the consequent handing over of the land to the Sunni Central Waqf Board shall be conducted simultaneously with the handing over of the disputed site comprising of the inner and outer courtyards as a consequence of the decree in Suit 5. Suit 4 shall stand decreed in the above terms. Section 6 of the Acquisition of Certain Area at Ayodhya Act 1993 empowers the central government to direct that the right title and interest in relation to the area or any part thereof, instead of continuing to vest in the central government, shall vest in the authority or body or trustees of any trust which is willing to comply with the terms and conditions as government may impose. Section 7(1) provides that the property vested in the central government under Section 3 shall be maintained by the government or by any person or trustees of any trust authorities in this behalf. We are of the view that it would be necessary to direct the central government to frame a scheme in exercise of the powers conferred upon it by sections 6 and 7 to set up a trust or any other appropriate mechanism to whom the land would be handed over in terms of the decree in Suit 5. The scheme shall incorporate all provisions necessary to vest power and authority in relation to the management of the trust or body chosen for the vesting of the land. Suit 3 filed by Nirmohi Akhada has been held to be barred by limitation. We have also rejected the objection of Nirmohi Akhada and of the Sunni Central Waqf Board to the maintainability of Suit 5, which was based on their plea that Nirmohi Akhada is a she-bait. Nirmohi Akhada's claim to be a she-bait stands rejected. However, having regard to the historical presence of Nirmohi Akhada at the disputed site and their role, it is necessary for this court to take recourse to its powers under Article 142 to do complete justice. Hence, we direct that in framing the scheme, an appropriate role in the management would be assigned to the Nirmohi Akhada. Stop.